Question 1. The single largest source of the Indian Constitution in terms of borrowed provisions is which of the following? A. The United Kingdom Constitution. B. The United States Constitution. C. The Government of India Act 1935. D. The Irish Constitution. The answer is C. The Government of India Act 1935. And here is why this matters. Most students instinctively say UK because they remember parliamentary system, cabinet, rule of law, and those are real. But the Government of India Act 1935 was the direct administrative template that the framers literally lifted structural provisions from. The federal scheme, the office of the governor, the public service commissions, the idea of an all-India service, emergency provisions, and the entire administrative machinery all trace back to 1935. Dr. Ambedkar himself acknowledged this. In fact, B.N. Rao, the constitutional advisor, used the 1935 Act as the working draft. The UK gave philosophical and procedural inspiration. The 1935 Act gave the skeleton. The UK is the second largest source in terms of depth of influence. Parliamentary democracy, cabinet system, nominal executive, rule of law, legislative procedure, single citizenship, the speaker's role, writs. But sheer volume of provisions, 1935 wins by a large margin. Now, you thought it was UK, didn't you? That is the #1 trap in every exam on this topic. Fix that right now. Question 2. The concept of rule of law in the Indian Constitution has been borrowed from which country? A. United States of America. B. Australia. C. United Kingdom. D. France. The answer is C. United Kingdom. Rule of law was conceptualized by A.V. Dicey, a British constitutional scholar. He gave it 3 meanings: supremacy of law, equality before law, and predominance of legal spirit. India borrowed this concept from the UK, and it finds expression in Articles 14 and 21. No one is above the law. Equality before law is guaranteed, and every act of the state must have legal authority behind it. Common mistake here. Students confuse rule of law with judicial review and write USA. Judicial review, the power of courts to strike down laws that violate the Constitution. That is USA. Rule of law, the philosophical concept that law governs everyone, including the government. That is UK. 2 very different things. One is a doctrine, the other is a power. Remember that. And speaking of courts striking down laws, which country gave India the power of judicial review? Let us go there right now. Question 3. The power of judicial review in India is inspired from which country? A. United Kingdom. B. Ireland. C. Australia. D. United States of America. The answer is D. United States of America. Judicial review means the Supreme Court and high courts can declare any law passed by Parliament or a state legislature as unconstitutional if it violates the Constitution. This came from the USA, where it was established through the landmark case of Marbury v. Madison in 1803. India incorporated this through Articles 13, 32, and 226. Question 4. Fundamental rights in the Indian Constitution draw inspiration from which country? A. Ireland. B. United States of America. C. United Kingdom. D. France. The answer is B. United States of America. The Bill of Rights in the U.S. Constitution, the first 10 amendments, was the model for Part 3 of the Indian Constitution. The idea that certain rights are so fundamental they cannot be taken away by ordinary legislation, that they are justiciable and enforceable through courts, that a writ can be filed before the Supreme Court. All of this traces to the American constitutional tradition. Now here's a trap the examiners love. The concept of liberty, equality, fraternity in the preamble is from France, not USA. USA gave fundamental rights as a justiciable part of the Constitution. France gave the ideals written into the preamble. Do not mix these two. And the writs, habeas corpus, mandamus, certiorari, prohibition, quo warranto, also have British origin in terms of their legal form, but their constitutional guarantee as a fundamental right in Article 32 is modeled on the American approach of making rights enforceable. Question 5. The directive principles of state policy in India were inspired by the constitution of which country? A. Australia. B. United States of America. C. Ireland. D. Canada. The answer is C. Ireland. The Irish Constitution of 1937 contained directive principles, non-justiciable guidelines for the state to follow in governance. India borrowed this concept wholesale and placed it in Part 4. The key word is non-justiciable. These principles cannot be enforced by a court of law, unlike fundamental rights. They are like a moral manifesto for the government. Ireland itself was inspired by the Spanish Constitution of 1931 when designing its directive principles. So there is a chain, Spain to Ireland to India. But for exam purposes, the direct source is Ireland. And nomination of members to the Rajya Sabha, that also came from Ireland. Currently, the President nominates 12 members to the Rajya Sabha, having expertise in literature, science, art, and social service. This concept of nomination draws from the Irish Senate model. Question 6. The method of election of the President of India by an electoral college using proportional representation through single transferable vote was taken from which country? A. United Kingdom. B. Canada. C. Australia. D. Ireland. The answer is D. Ireland. This one trips almost everyone. The framers borrowed the specific electoral mechanism from Ireland. The indirect election, the electoral college consisting of elected members of both houses of Parliament and elected members of state legislative assemblies, and the single transferable vote system, that is Irish. Do not confuse this with the U.S. presidential election system, which also uses an electoral college, but the American system uses direct popular vote per state feeding into electors, and the president is directly elected in a practical sense. India's system is more genuinely indirect and proportional, modeled on Ireland. Question 7. Which country's constitution inspired the concept of a federal system with a strong center in India? A. United States of America. B. Australia. C. Germany. D. Canada. Pause. The answer is D. Canada. This is one of the most tested facts in this entire topic. The Canadian Constitution Act of 1867 established a federation where residuary powers, powers not listed in any list, vest with the center. India copied this exact model. In USA, residuary powers go to the states. In India, they go to Parliament. Union List, Article 2048. Also from Canada, the appointment of state governors by the center. In the USA, governors are elected by the people of the state. In India, the governor is appointed by the president, which means effectively by the center. This reflects the Canadian model of a centralized federation. So remember the Canada package: strong center, residuary powers with center, appointment of governors by center. Question 8. The concurrent list, allowing both Parliament and state legislatures to legislate, was inspired from which country? A. Canada. B. Ireland. C. Australia. D. South Africa. The answer is C. Australia. Australia has a concurrent legislative list, and India borrowed this concept. The 7th schedule of the Indian Constitution has 3 lists: Union, State, and Concurrent. The concurrent list in Schedule 7 directly mirrors the Australian model. In case of conflict between central and state law on a concurrent list subject, the central law prevails. This is the doctrine of repugnancy under Article 254, also from Australia, the freedom of trade, commerce, and intercourse within India under Article 301, free movement of goods across states, that is an Australian idea, and the joint sitting of Parliament when there is a deadlock between Lok Sabha and Rajya Sabha on an ordinary bill, Article 18. That procedure was borrowed from Australia too. So the Australia package, concurrent list, freedom of trade and commerce, joint sitting of Parliament. Question 9. Emergency provisions in the Indian Constitution were primarily influenced by which constitution? A. United States of America. B. Weimar Constitution of Germany. C. Irish Constitution. D. Canadian Constitution. The answer is B. Weimar Constitution of Germany. The Weimar Republic of Germany which existed between the two world wars, had a provision allowing the suspension of fundamental rights during emergency. Hitler notoriously used this provision to consolidate power. India borrowed the emergency framework, the idea of a proclamation of emergency that centralizes power and can suspend rights, from this Weimar model. Articles 352 to 360 on emergency have German DNA. This is paired with the Government of India Act 1935, which also had emergency provisions that served as a domestic template. So emergency in India has a dual lineage, Germany for the philosophy, GOI Act 1935 for the administrative structure. Now here's the question that kills students in statement-based MCQs. Let us go there. Question 10. Statement-based MCQ. Consider the following statements. Statement 1. The concept of single citizenship in India was borrowed from the United Kingdom. Statement 2. The concept of dual citizenship exists in the United States, where citizens hold both state and federal citizenship. Statement 3. India follows the concept of dual citizenship, similar to the United States. Which of the statements given above are correct? A. 1 only. B. 1 and 2 only. C. 2 and 3 only. D. 1, 2, and 3. The answer is B. 1 and 2 only. Statement 1 is correct. Single citizenship, meaning every Indian is a citizen of India regardless of which state they reside in, was borrowed from the United Kingdom. In contrast, the USA has both state citizenship and national citizenship. You are a citizen of California and a citizen of the United States simultaneously. Statement 2 is correct. The USA does indeed operate a system of dual citizenship in the federal sense. State citizenship and federal citizenship coexist. Statement 3 is wrong. India does not follow dual citizenship. A person living in Maharashtra is an Indian citizen, not a Maharashtra citizen and an Indian citizen separately. There is only one citizenship. This is the UK model. This trap works because students see federal system and assume India copies federalism, fully including dual citizenship. It does not. India took Canada's strong center model for federalism, but took the UK model for citizenship. Question 12. Fundamental duties were added to the Indian Constitution by the 42nd Amendment in 1976. The concept of fundamental duties was primarily inspired from the Constitution of which country? A. Germany. B. Japan. C. USSR. D. France. The answer is C. USSR. The Soviet Constitution had a list of duties that citizens owed to the state alongside their rights. India's Swaran Singh Committee recommended incorporating fundamental duties on this inspiration, and the 42nd Amendment inserted Article 51A with 10 duties. The 86th Amendment later added an 11th duty, duty of parents to provide educational opportunities to children. This is frequently confused with Japan. Japan's constitution is the inspiration for the procedure established by law under Article 21 of the Indian Constitution, the protection of life and personal liberty, not fundamental duties. Two different things, two different countries. USSR, fundamental duties. Japan, procedure established by law. Keep those separate. Question 13. Which of the following features did India borrow from the Constitution of South Africa? A. Judicial review and fundamental rights. B. Emergency provisions and President's rule. C. Amendment procedure and election of Rajya Sabha members. D. Directive principles and nomination to upper house. The answer is C. Amendment procedure and election of Rajya Sabha members. South Africa gave India two specific features. 1. The procedure for amendment of the Constitution, particularly provisions requiring special majority. Article 368 of the Indian Constitution, which deals with constitutional amendments, has structural similarity to the South African model. 2. The method of election of members to the Rajya Sabha by proportional representation by single transferable vote in state legislative assemblies. Wait, students often confuse this with Ireland, which gave the method for the presidential election. Rajya Sabha members are elected by state assemblies using proportional representation. That is South Africa. Presidential election by proportional representation with single transferable vote. That is Ireland. The confusion is understandable. Lock it in right now. Question 14. The ideals of liberty, equality, and fraternity mentioned in the preamble of the Indian Constitution were inspired from the Revolution and Constitution of which country? A. United States of America. B. Soviet Union. C. France. D. United Kingdom. The answer is C. France. Liberté, égalité, fraternité. Liberty, equality, fraternity was the motto of the French Revolution of 1789. Dr. Ambedkar himself acknowledged in the Constituent Assembly debates that these ideals were taken from the French revolutionary tradition. They form the philosophical foundation of the preamble. This is a classic trap. Students see liberty, equality, and immediately write USA because of the Bill of Rights. But the Bill of Rights gives specific justiciable rights, freedom of speech, religion, assembly, the preamble ideals of liberty, equality, fraternity as philosophical aspirations. That is France. Different source, different purpose. Now let us go into the match and sequence questions, the ones where you need to hold 5 countries in your head simultaneously. Question 15. Match column A, feature, with column B, country of origin. Column A, 1. Concurrent list. 2. Residuary powers with center. 3. Directive principles of state policy. 4. Procedure established by law. 5. Fundamental duties. Column B, P. Canada. Q. Australia. R. Japan. S. USSR. T. Ireland. Which of the following matchings is completely correct? Concurrent list. That is Australia. Q. Residuary powers with center. That is Canada. P. Directive principles. Ireland. T. Procedure established by law under Article 21. Japan. R. Fundamental duties. USSR. S. Every single one is correct in option A. The trap options deliberately switch Canada and Australia in options B and C and move Ireland to a wrong position in option D. These confusions happen in real exams because students remember the country feature pair correctly, but then misidentify the letter during the match. Always verify the full chain before marking. Question 16. Negative MCQ. Which of the following is not correctly matched? A. Parliamentary system, United Kingdom. B. Judicial review, United States of America. C. Emergency provisions, France. D. Fundamental rights, United States of America. The answer is C. Emergency provisions, France. Emergency provisions were inspired by the Weimar Constitution of Germany, not France. France gave liberty, equality, fraternity as preamble ideals. Germany gave the emergency framework, the suspension of rights during a national emergency, the centralization of power. If you wrote France for emergency provisions in any exam, that would be a clean, wrong answer. Options A, B, and D are all correctly matched. Parliamentary system from the UK, correct. Judicial review from USA, correct. Fundamental rights from USA, correct. Question 17. Which of the following best describes what India inherited from the Government of India Act 1935? A. Concept of fundamental rights and judicial review. B. Directive principles, fundamental duties, and preamble. C. Federal scheme, public service commissions, and office of the governor. D. Parliamentary system, cabinet responsibility, and single citizenship. The answer is C. Federal scheme, public service commissions, and office of the governor. The Government of India Act 1935 was the immediate predecessor to the Indian Constitution and provided the structural and administrative backbone. From it came the federal scheme, the division of subjects between center and states, the All India Services and Public Service Commissions, the idea of an independent civil service insulated from political interference, came from 1935. The office of the governor as an appointee of the center came from 1935. Emergency provisions in their administrative shape also traced to 1935. Option A belongs to USA. Option B is a mix of Ireland, USSR, and the Constituent Assembly's own work. Option D belongs to the UK. The 1935 Act is the domestic legal ancestor, not a foreign constitution, and that is precisely why it contributed the most provisions structurally. Question 18. Assertion-Reason MCQ. Assertion A. India follows a parliamentary form of government similar to the United Kingdom. Reason R. In both India and the United Kingdom, the constitution is unwritten, and the president or monarch is only a nominal head. A. Both A and R are true, and R is the correct explanation of A. B. Both A and R are true, but R is not the correct explanation of A. C. A is true, but R is false. D. A is false, but R is true. The answer is C. A is true, but R is false. The assertion is correct. India does follow a parliamentary system inspired by the UK. The executive, the Council of Ministers, is responsible to the legislature, Lok Sabha. The Prime Minister is the real executive, and the President is the nominal head. But the reason is wrong, and this is the trap. The UK Constitution is unwritten. It is based on conventions, statutes like the Magna Carta, and judicial decisions. India's constitution is fully written. It is one of the longest written constitutions in the world, so the comparison breaks down at that point. Both countries share parliamentary democracy, but not both have unwritten constitutions. India has a written constitution, borrowed partly from the concept of written constitutions used in the USA and many others. The examiner inserted unwritten into the reason specifically to catch students who know A is correct and rush to mark option A without reading R carefully. Read every word. Question 19. Scenario-based MCQ. A law student argues that since the Indian judiciary can strike down laws passed by Parliament, it proves India has adopted the American model of separation of powers completely. Is this argument correct? A. Yes, India fully follows the American model of separation of powers. B. No, India follows parliamentary system from the UK, where judiciary does not review laws. C. Partially correct. India has judicial review from USA, but follows parliamentary system from UK, so separation of powers is not rigid. D. Incorrect. The power to strike down laws belongs only to the president in India. The answer is C. India is a unique constitutional blend. From the USA came judicial review, the power to strike down unconstitutional laws, but from the UK came parliamentary democracy, where the executive comes from the legislature. They are not strictly separated. In the USA, the President, Congress, and Judiciary are three completely separate branches with checks and balances. In India, the Prime Minister and Cabinet sit in Parliament. They are part of the legislature while running the executive. That is the UK model. So India has borrowed judicial review from the USA, but has not adopted the rigid separation of powers the USA operates. The Indian model is sometimes called separation of functions rather than separation of powers. The student's argument is only half right, which makes option C the correct answer. This type of integrated conceptual question is exactly what appears in essay-type MCQs and judiciary prelims. The examiner tests whether you can hold two countries in your mind simultaneously and identify the precise blend. And now, the final type, the ones students dread. The which of the following statements are correct format, with 3 statements and a twist. Question 20. Consider the following statements. Statement 1. The bicameral legislature in India, Lok Sabha and Rajya Sabha, was inspired by the British Parliament of Lords and Commons. Statement 2. The joint sitting of Parliament in case of deadlock between the two houses was borrowed from Australia. Statement 3. The concept of cabinet system with collective responsibility to the lower house was borrowed from Ireland. Which of the statements given above are correct? A. 1 and 2 only. B. 2 and 3 only. C. 1 only. D. 1, 2, and 3. The answer is A. 1 and 2 only. Statement 1 is correct. Bicameralism, having two houses of the legislature, is structurally influenced by the British Parliament. The House of Lords inspired the idea of an upper house, and the House of Commons inspired the lower house concept. Statement 2 is correct. Joint sitting, Article 108. When a bill is passed by one house and deadlocked in the other, a joint session of both houses can be called. This came from Australia. Statement 3 is wrong. Cabinet system with collective responsibility. That is UK, not Ireland. Ireland gave DPSP and nomination of Rajya Vapa members. Collective responsibility of the cabinet to the Lok Sabha. That is a pure UK feature. The trap is designed to make you replace UK with Ireland for cabinet responsibility. Question 21. Which of the following is correctly matched? A. Procedure established by law, United Kingdom. B. Rule of law, United States of America. C. Impeachment of President, United States of America. D. Presidential election by Electoral College, Australia. The answer is C. Impeachment of President, United States of America. Option A is wrong. Procedure established by law under Article 21 came from Japan, not UK. The UK contributed rule of law. Option B is wrong. Rule of law came from UK, not USA. Option C is correct. The procedure for impeachment of the president was inspired by the USA. Option D is wrong. Presidential election by Electoral College using proportional representation and single transferable vote came from Ireland, not Australia. Lock in this cluster. USA, Judicial Review, Fundamental Rights, Impeachment, Independence of Judiciary. UK, Parliamentary System, Cabinet, Rule of Law, Single Citizenship, Speaker, Writs, Legislative Procedure. Japan, Procedure established by law. That is Article 21's procedural protection. Ireland, DPSP, nomination to Rajya Sabha, presidential election method. Canada, strong centre, residuary powers, appointment of governors. Australia, concurrent list, freedom of trade, joint sitting. Germany, emergency provisions. South Africa, amendment procedure, Rajya Sabha election method. France, liberty, equality, fraternity in Preamble. USSR, fundamental duties. GOI Act 1935, federal scheme, governor's office, PSCs, administrative structure. That is the complete map. Every country, every feature. If a question is from this topic, it lives somewhere in that cluster. You now have the full architecture. Go back to question 1. Think about it again. Still think it was UK? The Government of India Act, 1935, always.